Our first question comes from Rashonda, and she has a question about the times that we're living in. Her question is, if you go into a hospital and end up catching COVID or some other kind of illness that you didn't have when you went in, can that be considered malpractice?
I would doubt it. I mean, it's kind of like an infection that you get in the hospital, whether you get MRSA or some kind of infection. It's just there. It's a risk of going in. I guess there could be a breach of some protocols that might raise an issue of fact about it. But more likely than not, I would say it is not a medical malpractice issue. What is your take on that, BJ?
Yeah, you're right. The legislature passed a law back during the pandemic that you might have noticed. You go in businesses now, they have a big sign on the front door that says, pursuant to such and such a code section, we're not responsible if you catch COVID. So you see those because if the law says if you have that on your front door, they can't hold you liable or sue you for getting COVID. Whether that's enforceable or not is another question, but you'll see that outside.
Okay. Well, let me ask you this. What if you go in there, they have the sign on the door, and they, have people in the ER who are admitting people, and they know that they have a COVID patient in a room, and you are elderly and have comorbidities, and they take you and put you in that room with those people. Does that take that beyond the statute passed by the legislature?
Well,
or are you a prisoner of that?
No, I think the statute also provides, as I recall, there's a heightened level of care or culpability you have to show. So if they're negligent, maybe not, but if they did something more egregious, you may be able to hold them accountable.
So it's almost like the emergency room statute.
Right, similar to
show a showing of not even slight care.
Right.
And Morgan, that brings us to another question that BJ raised, the issue of the legislature and our General Assembly, who back in 2005, I believe it was, BJ,
correct, yes,
passed a bill that said that in order to hold anybody performing emergency room work or emergency procedures was held to a much higher standard in terms of proof of negligence. You had to prove gross negligence. And it's hard enough to bring a malpractice case to start with. The thing that defeats them mostly is that it is so time intensive, it's so expensive, it's emotionally trying to bring forth a medical malpractice case. And there are many medical malpractice cases that never see the light of day because they don't involve sufficient injuries or damages. And that's the sad state of affairs.